Hello everybody, welcome to my another seminar in Denver. It's always nice to be back here in Colorado to meet with all of you and to answer your most urgent immigration questions. Today I'm going to briefly speak about the new immigration policy that was announced by the USCIS on May 22nd, 2026. The new policy states US Citizenship and Immigration Services today announced a new policy memo reiterating the fact that consistent with long-standing immigration law and immigration court decisions, aliens seeking adjustment of status must do so through consular processing via the Department of State outside of the country. Officers are directed to consider all relevant factors and information on a case-by-case basis when determining whether an alien warrants this extraordinary form of relief. We are returning to the original intent of the law to ensure aliens navigate our nation's immigration system properly. From now on, an alien who is in the US temporarily and wants a green card must return to their home country to apply, except in extraordinary circumstances. This policy allows our immigration system to function as the law intended, instead of incentivizing loopholes. When aliens apply from their home country, it reduces the need to find and remove those who decide to slip into the shadows and remain in the US illegally after being denied residency, said USCIS spokesman Zach Kaler. Non-immigrants like students, temporary workers, or people on tourist visas come to the US for a short time and for a specific purpose. Our system is designed for them to leave when their visit is over. Their visit should not function as the first step in the green card process. Following the law allows the majority of these cases to be handled by the State Department at the US consular offices abroad and frees up limited USCIS resources to focus on processing other cases that fall under its purview, including visas for victims of violent crime and human trafficking, naturalization applications, and other priorities. The law was written this way for a reason, and despite the fact that it has been ignored for years, following it will help make our system fairer and more efficient. So basically, this is in a nutshell what the policy announced. It came effective immediately on May 22nd, 2025, and as you can see, it's going to affect most of the adjustment of status cases that are either already pending or are about to be filed with the USCIS. Since this is a very sensitive subject and needs to be closely watched, and you need to pay close attention to any developments of the application of this policy going forward, I am going to spend time after this presentation to speak to each of you individually and address each of your individual questions on case-by-case basis. Right now, I just wanted to briefly explain what the new policy is about, and this is for the benefit of my online viewers. Absent extraordinary circumstances, even if your case is otherwise super clean, you may basically be denied. If you're applying for the adjustment of status here and you came on a different type of visa, not the immigration visa, and not on a fiancé visa, for example, and you're applying for adjustment of status based on marriage, you need to be cautious, and you need to keep in mind that the officers will now have much broader discretion to decide your case, and they may deny your case if they don't find that your case falls under extraordinary circumstances. Some examples of extraordinary circumstances may include, for example, a 3-year or 10-year bar from coming back to the country if you're sent now, if you overstay your tourist visa or your ESTA, or your other type of visa. They may or may not, it's going to be in discretion of the officers. There may be some medical circumstances, there may be some family situations, or some other circumstances that we can discuss individually with each of you. However, you need to pay close attention to this policy, because this is already being implemented and it may seriously affect your case. If you would like to receive more information regarding this policy, please come to me after this presentation and I'll talk with each of you individually. Thank you very much for showing up to this seminar, and it's always nice to see you here in Denver. Thank you very much and have a great day. Hello again. So after speaking to many of you about your individual situations, I feel there is a need for some summary regarding how is this situation going to affect applicants. So to sum it up, this new policy applies to applicants for a green card who are applying for adjustment of status, which means they are applying for a green card here in the United States. The new policy applies to most of the people who came here on different type of visas. Not all of them, there are exceptions. However, people who it does apply to are people who came here on tourist visas, for example, or on ESTA, and they're applying for a green card through marriage or through family. People who came here on student visas or temporary worker visas. All those categories fall under this new policy. So these people are directed to go back to their country and apply through consular processing for a green card unless extraordinary circumstances occur. So basically, the immigration officers will now have a broad discretion to deny your case just because you came here on a visa that is not for the purpose of applying for a green card. A tourist visa is a perfect example of such case. Basically, someone comes here as a tourist on a short tourist visa, and that visa is designed in a way that you're supposed to go back. You have a stamp in your passport that, or you have a I-94 record that tells you exactly how long you can stay here. And within that time, you're supposed to go back. If you didn't do that and you stayed, and you then filed an application of adjustment of status for a green card, that may be considered you're not allowed to do that, basically, absent extraordinary circumstances. So it's going to be now the burden of proof is going to be on applicants to show that extraordinary circumstances apply to their case. Some people have a very difficult situation because they already overstayed their visas. So basically, someone could have overstayed their tourist visa by more than 180 days. And in that situation, you have a ban from returning to the United States for 3 years. And that's regardless if your application is approved, you're still not going to be able to come back because you have to wait 3 years before coming back. If you overstayed your visa for more than a year, then you have a ban for 10 years from coming back to the United States. So that adds up to the difficulty of the situation. If you're still within your allowed period of time, then you still have the choice. You still can go back without consequences. And in that situation, you should go back and apply for a green card from your country. So what are extraordinary circumstances? A lot of you have been asking me that, and this is going to be decided on case-by-case basis. So everybody can have different extraordinary circumstances. It's going to be ultimately up to the immigration officer who's deciding your case to interview you and to decide if this is extraordinary or not. So it's very hard for me to tell you what's extraordinary circumstances, because it depends, you know. It's going to depend on many factors. Some examples of things that may or may not be considered extraordinary would be a family hardship, a situation in your family. For example, someone is gravely ill and you're taking care of them, and they're a US citizen, and you cannot be separated. You have a small child that is totally dependent on you and you cannot go back. Or you, for example, you're a victim of a crime in your own country and you're afraid of coming back. Or you may have nothing to come back to. You may have no family, no resources to go back to your country. And especially that would be difficult if you are already subject to a ban, 3-year or 10-year ban from returning. Some other people may have a situation that they don't even know their home country because they were brought here as children. They may be DACA recipients, people who were brought here when they were 2 years or 3 years old, or about that age, and they don't even speak their native language, or they barely speak their native language, and they may not have any family members left in their country of origin. So those may be extraordinary circumstances, but really it's too early to say how this policy is going to be implemented. So you just need to get prepared according to your best ability. Get an attorney if you can afford an attorney. It's definitely worth it in this type of uncertainty, and do your best to defend your case. If you still can go back without consequences, without a ban, it's definitely worth going back and applying for a green card from your country. I think that would be all. I think I addressed most of your questions, and again, if you need more information, you can always contact me directly, call me or email me. Thank you very much.